Hello, this is Ian Brodsky with Windy City Legal, where we focus on estate planning and real estate matters. In this segment, we're going to talk about the difference between the responsibilities of a trustee, an executor, and an agent acting under a power of attorney. Before we get to that, if you have questions about estate planning, you can go to windycitylegal.com. There will be a link for you to pick a time, sign up for a time to chat. That's all over at windycitylegal.com. Okay, so what are the differences between the responsibilities of a trustee, an executor, and an agent? Before I get to that, I'm going to refer to the person that is creating all of these documents as a signer for purposes of this video. In each possible document, they may have a different name, such as a grantor of a trust, a testator under a will, and a principal under a power of attorney. I want to avoid that confusion, so I'm just going to call them as signers for each of those documents. Okay, so in a trust, the trustee is the person who has the authority to administer the trust and any assets that it holds. This is true during the signer's lifetime, and after the signer passes away, the trust will continue in existence. The first trustee may be the signer, or it may be somebody else, and then successor trustees may be allowed after the signer is no longer able to act for himself or has passed away. But in a nutshell, the responsibility of the trustee is to act to administer the trust and its assets, and to do so during the signer's lifetime and after. An executor of a will is a little bit different. The executor's responsibilities only begin when the signer has passed away, and then the executor will administer any assets that are not held in trust or that pass to beneficiaries directly. He'll also be responsible for taking care of the other aspects needed to wrap up an estate, which may include filing any tax returns, distributing any assets, dealing with any debts that the signer may have incurred, and any other outstanding matters to resolve that estate. But again, the executor's responsibilities do not begin until the signer has passed away. The agent acting under a power of attorney is a little bit different. The agent is appointed to act on behalf of the signer during the signer's lifetime in the event that the signer is not able to make decisions for himself. So in a property power of attorney, that would involve making business decisions, dealing with bank accounts, paying bills, etc. In a healthcare power of attorney, that would involve making healthcare decisions subject to any restrictions that the signer has put in the power of attorney. But again, these are only in effect during the signer's lifetime. Any authority granted under the power of attorney automatically ends upon the signer's death. So for each of the three documents, it's a slightly different timing. In the case of a trustee, it's during and after the signer's lifetime. In the case of a will, it's only after the signer's lifetime, and in the case of a power of attorney, it's only during the signer's lifetime. I hope this has been helpful. If so, feel free to like or subscribe, and there will be you'll be able to receive additional content as it's issued. If this has been helpful, or if you think this would be helpful to somebody that you know, feel free to share it with them. And as always, if you have questions, feel free to go to windycitylegal.com and pick a time for us to chat. Once again, I'm Ian Brodsky with Windy City Legal. Thanks for listening. I appreciate you guys. Have a great day, and we'll talk to you again soon.